There.
Aloha everyone. My name is Tommy Pickard, Konohiki. I'm reading a generational trust court case on Allodial Titles for Kanaka Maoli. Okay? So, court case Ki'iki'i versus Edward Dennis. This was an action of trespass brought by a plaintiff, a native, to recover damages alleging that the defendant had taken away one of his kalo patches. The plaintiffs proved that the taking and offering in evidence of a royal patent for the land based upon an award from the Land Commission and dated in December 1850. As proof of his title, the defendant offered in defense a royal patent for his land, which covered the land in dispute hearing date in 1849. The contended that his patent being of an anterior date gave him the best title and was a full jurisdiction for the taking. As a further defense, the defendant showed that the plaintiff had refused to go to his labor 3 days each month and had made a verbal surrender of the land in dispute. It appeared, however, that in the royal pattern conveying the land to the defendant, the king had made an express reservation of the claims of the tenant. Okay.
My turn.
Oh, yeah, my turn.
This is you.
Okay.
Yeah, you go to the all the way to the tower. sorry, Cynthia.
And pick up the towel.
Right, yeah.
Lee C.J., after giving a succinct history of the landed tenures of the kingdom, charged the jury that the defendant could not justify the taking under his royal patent, the king having expressly reserved in that conveyance the claims of native tenants, that Ki'iki'i was one of those tenants who had duly entered his claim at the Land Commission previous to the date of the defendant's patent, and subsequently in 1850 received his award and patent. That consequently the plaintiff's title was good against all the world. Moreover, said the court, even if the king had not made this reservation, the plaintiff's title would be good, for the people's lands are secured to them by the constitution and laws of the kingdom, and no power can convey them away, not even that of royalty itself. The king cannot convey a greater title than he has, and if he grants lands without reserving the claims of tenants, the grantee must seek his remedy against the grantor and not dispossess the people of their kalo patches.
Hello, Kelvin Hule, Konhiki. The court also charged the jury that the defendant had no rights to demand 3 days labor in every month from the plaintiff, and though they should find that Ki'iki'i had made a verbal surrender of the patch, yet if there was no valuable consideration given for such surrender, it was not binding upon the plaintiff. The jury, after a short absence, rendered a verdict for the plaintiff in the sum of $25. C.C. Harris, exquisite for plaintiff. John Montgomery, exquisite for defendant. Kapana versus John Watson. This action was precisely similar to what of K.E. versus Edward Dennis and did not come to trial, the counsel settling the same out of court. C.C. Harris, exquisite for plaintiff. John Montgomery, exquisite for defendant. Amen. Thank you. There's some more? Oh, excuse me. There's another page. Don't no, really.
No, this the second most important case
This, which one?
is right here, Kepney versus
Oh.
John Watson. This is-
Kapani versus Johnson Watson. This action was precisely similar and did not come to trial. The counsel settling the same out of court. C.C. Harris, exquisite for
In-
plaintiff.
In other words, the people don't have to go to court.
In other words, the people, they don't have to go to court for this kind of situation, these issues about lands, about claiming their lands,
Yeah.
about their kingdom land. Thank you. Amen.